Alright, so state and federal court systems. Certainly there's several different layers within the court system. You have your local courts with limited jurisdiction. You also have your state trial courts with general jurisdiction. And that's what we talked about earlier in the chapter. Certainly general jurisdiction would be state court, superior court. Limited jurisdiction for Georgia would be probate court, juvenile court. You also have state courts of appeals, Georgia Court of Appeals, and you have the state's highest court, and that would be the Georgia Supreme Court. Now, trial court is what most of you are probably familiar with. This is what you see on TV because it's exciting. Oh yes, don't you just love it? Can't you just see it? We're going to sue Superman. Who would ever want to sue Superman? But anyway, if you were to sue Superman, you would start at the trial court. Okay, probably go to Superior Court here in Georgia. If it was a minor infraction, you might go to small claims court. It could be that Superman accidentally, I don't know, with his heat vision burn up some of your grass. Okay, and that would be for small claims court because those are inferior courts. They hear only civil cases involving claims of less than a certain amount, so just $5,000. Certainly, if Superman's heat vision were to burn just some of your grass, I don't think it would be more than $5,000. Okay, so that would be small claims court. Anyway, but once you go to trial, you hear all the facts, you hear all the evidence, all the testimony, all the witnesses, all that stuff you see on Perry Mason and Judge Judy. Judge, what was his name? That other judge? Yeah. Judge Alex. I argue with those shows. You go to the Court of Appeals, alright? And every state has at least one Court of Appeal. Okay? Georgia even has one. Generally, this is 3 or more justices who sit on a panel and they listen to your case brief, try to figure out what's going on, and they decide questions of law. How did the trial court err? Alright? Their main question is, what is the law? And for attorneys, this is arguably a lot of fun because you're not dealing with witnesses, you're dealing with, what is the law? So you go before these justices and you argue the law. Okay? Questions of fact, those deal with what really happened in regard to the dispute being tried. And generally that's what you're going to see at the trial level. Okay, you're still not happy with the Court of Appeals, you appeal again. You go to the state Supreme Court. And usually, it's called the Supreme Court, but they're going to handle questions of law, state law, and they're generally the final phase. Now, you can go on into the federal system, but remember, generally there's only 2 ways to get there, and that's federal question and diversity. Alright. You'll notice the federal system is set up very similar to how the states are set up. Okay, 3-tiered model. Your U.S. district courts. Those are your trial courts. U.S. Court of Appeals is usually divided up into circuits. Coincidentally, Georgia's in the 11th Circuit. And we have the United States Supreme Court. Okay, so there's 3 different levels. District court, like I said, is like the trial. Court of Appeals. Divided into 13 circuits. Georgia's in the 11th. And you have the United States Supreme Court. And this is the highest court in the land, the Supreme Court. Okay? All other courts are inferior. Okay? So, if He-Man, yeah, you like that. If He-Man, has a case before the Supreme Court, and the Supreme Court decides that, yes, in fact, he is the master of the universe, and Skeletor is just a wuss, then yes, that's the end of it. That's the Supreme Court. Will that happen in real life? No, but I thought you'd like seeing He-Man. Alright. How do you get there? Well, obviously, they have original jurisdiction on a few things. But 9 times out of 10, you're going to try to get there by writ of certiorari. Writ of certiorari is you're asking the court to actually hear the case. Alright? You're saying, hey court, listen. This is what happened. We need you to hear this case. And if 4 of the justices agree to hear it, it's the rule of 4, boom, you're in front of the Supreme Court. Okay? What else do we have? We have judicial procedures. following a case through the trial. Okay, you have American and English courts, and basically both of them follow what we call an adversarial approach, meaning that you'll have two lawyers arguing over things. Okay, this is always a lot of fun. Generally, they're going to follow what we call the Federal Rules of Civil Procedure, and this is going to be applicable to federal cases, district court, U.S. Court of Appeals, U.S. Supreme Court. But a lot of states model their state procedure laws based on the Federal Rules of Civil Procedure. So how do we start this? Well, let's go and consult with an attorney. Nice people. Yeah, everybody should have to be friends with lawyers. Yeah, and everybody should be friends with doctors too. But anyway, an attorney will generally let you know what will happen in a lawsuit. Well, listen, this is the procedure. This is what we're going to do. We're going to file a complaint. They'll file an answer. This is what's going to happen. This is what information we need for you. This is how much I'm going to charge you. Yada, yada, yada. Okay? So, generally the first time you meet with a lawyer, that free consultation they always tell you about, that's what you're getting. They're telling you all about that stuff. But what actually starts happening once you retain an attorney? You have certain procedures. You have pleadings. Alright? The complaint and the answer. Alright, this is how you inform each party the other's claim and specify the issues involved in the case. Alright, so the plaintiff. Alright? Again, we have Superman and He-Man. Alright? Coincidentally, I have the original He-Man figures, and I probably have the original Superman figures, but I thought that these were kind of cool. They were birthday presents. Yeah. So He-Man is going to sue Superman for battery, because clearly Superman hit He-Man. Boom, battery. Got it. Okay? So we have a complaint. He-Man is going to file the complaint because Superman hit him. Okay? So he has to show the court that there's jurisdiction. Alright, so where are we going to sue? Well, wherever Superman resides, which is what? Metropolis. Alright? Shows the facts of the case. Alright? Well, Superman hit him. They're going to lay out all the facts that lead up to that. And the remedy that He-Man is seeking. Obviously, damages, lost wages, whatever. Alright? Then we're going to have to do service of process, meaning we're going to have to tell Superman that he's been sued. Alright? Yes, he has X-ray vision, he can fly, but I don't think he can read minds. So we have to serve him. Okay? Service of process is notifying the defendant of a lawsuit. You actually got to serve him. With the complaint, you'll usually have a summons. Notice requiring the defendant, aka Superman, to appear in court and answer the complaint. Okay? If Superman does not answer the complaint after X number of days, then guess what? You get a default judgment. In Georgia, it's 30 plus a 15-day extension. But if you don't answer that complaint, then you get that default judgment and He-Man automatically wins. Alright? So how are we going to do this service? Service. Well, if you remember, we have the Federal Rules of Civil Procedure. Well, under the federal rules, anyone who is at least 18 and is not a party to a lawsuit can serve process in federal courts. Okay? I could do it. Most of you could do it, as long as you're over 18. In state court, the process server is often the county sheriff. Okay? Or an employee of an independent company that provides process service in the local area. Process can be done by leaving it with the defendant. Okay? So I take the complaint and the summons, and I personally hand it to Superman. That's service. Mail it if the defendant consents. Okay? Sometimes the defendant may not be available. Then you have to do service by publication. Put it in the local newspaper. Or via email in certain circumstances. If you're going to serve a corporation, you do it to their registered agent by contacting the Secretary of State, looking at their incorporation documents and finding out who the registered agent is. Sometimes this can be waived. Alright? Certainly, defendants may waive or give up their right to be served personally. You can mail the complaint and summons to the defendant, Superman. If he signs off on it, takes it, and mails it back, hey, you got service. Alright? So, Superman gets the complaint. Here he is. He's just been sued. Do you think he's very happy? No. Okay? But just because He-Man said he did something wrong, does that mean he did something wrong? I mean, no, this is Superman. Superman doesn't make mistakes. But he can answer. He gets an opportunity to give his side of the story. Okay? So, in the answer, the defendant either admits or denies each of the allegations in the plaintiff's complaint, and may also set forth defenses to those allegations, namely, I am the Man of Steel. Whatever. Alright? Also brings up affirmative defenses. Raise facts to show that the defendant should not be liable for the damages. Hey, I didn't do anything. And then guess what? Counterclaims. Superman can turn around and sue He-Man right there. Set forth the defendant's claim that the matter occurred as a result of the plaintiff's actions. Right? Superman didn't commit battery. He-Man actually, said, hey, come on, hit me. Counterclaim. Okay? Dismissals. Alright? You do this by motion. Procedural requests submitted to the court by an attorney on behalf of their client. Right? There are dozens of pretrial motions. You can actually check out the list on page 48, Exhibit 2-6. You got a motion to dismiss. Requests the court to dismiss the case for reasons stated in the motion, although normally it is that defendant who requests the dismissal. Motion for judgment on the pleadings. Ask the court to decide the issue solely on the pleadings without proceeding to trial. So we're going to look at the complaint and the answer. Or we got summary judgment. Granted only if the evidence, when viewed in the light most favorable to the other party, clearly shows no factual dispute and contention. Right? This is done with affidavits, sworn testimony. Alright? Well, once we go through the pleadings, let's start discovery. And discovery, the way it was taught to me, is this is going through the other side's underwear drawer. I know that probably sounds kind of sick when we're talking about Superman and He-Man, but think about it for a second. Where do you keep your most intimate secrets? In your underwear drawer. I rest my case. Alright? How do we get discovery? How do we find everything out? Well, we ask. We do depositions, interrogatories. A deposition is sworn testimony by a party to the lawsuit by any of their witnesses. Okay, recorded by an authorized court official. So you go to the attorney's office, you sit there in the conference room, you got the court reporter, they're typing away, and opposing counsel is asking you questions. That's a depo. Interrogatories, on the other hand, is written questions, for which written answers are prepared and then signed under oath. So in both of these cases, you are swearing under oath, or affirming under oath, that what you say is true. Again, we're just gathering information. Request for admission. Written request on the other party with a written request that admission of truth to the matters related to the trial. We're asking you, hey, is this true? Request for documents. All right, asking permission to view these items. Examinations. Asking, hey, we have an accident here. He-Man got hit. We want our medical examiner, namely Superman's, to examine He-Man and make sure he really is in bad shape. You even have electronic discovery. Believe it or not, everything on your laptop is discoverable. Yeah, it's kind of scary. Pre-trial conference. Alright? This is the informal discussion between the judge and opposing attorneys after discovery is taking place. It's basically the judge saying to the attorneys, guys, I want you to settle this thing. I want to go play golf tomorrow. You think I'm kidding? Right to a jury trial. This comes from the 7th Amendment. Certainly it's something you want to ask for in your initial complaint because it's not been incorporated into the 14th Amendment. If there is no jury, though, the jury determines the truth of the facts alleged in the case. So if there is no jury, the judge determines those facts, pardon me. And then we have jury selection. This is voir dire. You go in and you ask questions of the jury to make sure they're not biased. You can use precatory challenges, which are generally limited in number, and you can ask a prospective jury to be dismissed for whatever reason, having a brown and blue shirt, liking the University of Georgia, that would be grounds. But you can't discriminate based on sex, creed, national origin, race, all that good stuff. But you can also dismiss for cause, meaning that there is a bias there.